Hello everyone, welcome to another interview of Tips to Talk the Unofficial Bar. I have with me today President Counsel K. Kanag Ishwaran, uh, a well-reputed, eminent lawyer in Sri Lanka, and he is going to share with us tips to top the unofficial bar. Sir, I would like to first hear from you. How did you begin your career? Would you like to explain the early period of your professional career?
Well, I started my legal education in the United Kingdom, in London, at the University of London. I did my law degree LLB and concurrently also read for my barrister's at law examination at Lincoln's Inn, and I was called to the bar in England in 1964 June. I practiced there for a short while and returned to Sri Lanka in 1965 November and took courts here as an advocate in July 1966. At that time we didn't have a fused profession, we had advocates and proctors. So advocates were counsel who had the right of audience in the Supreme Court and the district courts, and so that's what they are called, advocates. As you know, in 1972 the profession was fused. When we first came here, we of course, like all fresh lawyers, we were what we call briefless barristers, because nobody will entrust a brief to you because you're a raw junior. So my advice, and what we did then was, even today perhaps you ought to be doing that, is the easy brief is when you have go to the criminal court, because accused are arraigned and they have the money to pay, and we then have a system, I think even now it is there, system of the court assigning counsel to defend criminals who are brought up for trial for various kinds of offences. Those days the criminal sessions took place either before the judges of the Supreme Court or judges called commissioners of assize, who were commissioned to conduct criminal trials. And on the opening of the first day of the sessions, all of us go, briefless barristers, young lawyers, we go and sit in court, and the court will assign to us a particular criminal case. It may be murder case, may be rape case, counterfeit case, and we have to go and collect the brief from the registrar of court, and he will give it to us. Then we go and interview the prisoners and then appear for them in court. We are paid 31 rupees 50 cents a day for the first 2-3 days. After that it's a free run. The idea was not to make money, idea was to get an experience in court. That is the way to start a profession, is to get an experience of court. You don't look for money only. Unless you pay me this much, I am not appearing. That appears to be the current approach, but that is all wrong.
Wow.
So we used to do that. Not only there were sessions in Colombo, in Kalutara, Panadura, right down the coastal areas, in Kandy. So we used to go whenever sessions opened in the provinces, go there and also wait to collect these free briefs. Basically they were free. Idea being, you have to get the experience. Another advantage we had as barristers at law was that the highest court in the criminal jurisdiction was a Court of Criminal Appeal. That was presided over by 3 judges. And the local advocates could go there only after 3 years of practice. As barristers, we could go in straight away. So there you had the advantage. There again, you were given an assigned brief, but you were paid 52 rupees and 50 cents for a day, 2-3 days. There you are arguing in appeal, the criminal appeal briefs, and you are pitched against top senior Crown Counsel at that time from the AG's department. You see, top guys. Now I appeared before Justice Sittavala, Justice Vanasundara, Mr. Shiva Pasupati, all those big guys who are solicitors or even lower, you will come to the Court of Criminal Appeal. And one good thing was, judges those days, 3 judges heard it, and they always helped junior counsel. Either put your Mr. So-and-so, don't you think this is the point that you should be urging? And we, of course, haven't thought about it. They say, yes, my lord, and you. They sometimes, in my case, there used to be Justice Vijay Tilaka, now current Solicitor General's father. He was a very nice man. He was very fond of junior counsel. He will put arguments into our mouth and hold with us against even senior people in criminal matters, where you can see the justice demanded, but that you were a raw fellow, you probably didn't know how to. So you learn a lot. That's one way. The other way is when we go to the civil court, district court there, then we had only the district court, as the original civil court. There were no high courts. There we go and sit and listen. We have those what we call the big monitors exercise books. They used to call it CR books, the government sort of thing. There we sit and listen to arguments and make notes. The point I am making is those days authorities were cited, presentations were made orally so that juniors could listen and learn. Now everything is done on written submission. Nobody opens their mouth. Written submissions and computer generated things, so nobody learns anything. The juniors don't learn from the seniors because what the seniors have to say is put it in writing. Okay. Those days we hear beautiful arguments, the Supreme Court, in the district courts. When you had no work, you will go there and sit and listen. They cite authorities on prescription. Those days majority cases were civil and land cases, not much commercial law at that time. So you learn everything under the sun. You go to the criminal court, you learn about how do you cross-examine, on burden of proof, and how the state will not meet the judge in chambers without the presence of the defense attorney. That was a practice that no counsel will see the judge alone except in the presence of the opposing counsel. So, if the defense counsel wants to go and see the judge in chambers or a particular case, then he must inform the Crown Counsel, both will be there. Crown Counsel, if he goes, he can't go and see the judge alone. Now I am told the practice, they go and have a big chaka chava and then come out. We don't know. So I am told. Because I remember one murder trial I did before Justice Veera Mantri was a then Commissioner of Excise, 1967 I think, the year after. And I had a case, a murder trial, about Indian, one from the slums, Kotayana slums. This fellow was having an affair with his landlady, and the husband was murdered. So his explanation was that he was helping the wife to peel onions, and the husband came drunk and started abusing her, and he said get away, and accidentally the knife cut the neck. That was his defense. I said I didn't believe it. He said that's a you can't. If the man says that, you are supposed to believe in what he says. So I let this one at the adjournment, Justice Veera Mantri called me to the chambers and told me, the way you are going to, if this man is going to be sentenced to death. I said, put it to him, ask him to accept culpable homicide, not wanted to murder. I said, yes sir, I'll go and speak. I spoke to the fellow, he said, Ayya is a Tamil fellow. Ayya, I didn't do it. So I went to him, sir, he denied. I said, okay, go ahead. For that fellow's luck, when I addressed the jury, his luck, jury accepted it and they found him guilty of culpable homicide, not attempted murder. The point is this, end of the trial when all have urgent, this fellow fell at my feet and worshipped me, and he said, he did it, that is, he murdered. After that, I gave up criminal practice. I did in between counterfeit cases, how we can use these tortoise shells and things like that to counterfeit 1 rupee coins. They do this and stand outside the pansala, and people buy the vatti and all that, they give the change. You can, now I know how to counterfeit coins, how to find out, I know. Because there is a ribbed edge on a coin, like that. Counterfeit don't have that, it's very polished. Like that, you learn those things, But, Justice Veera Mantri was helpful. Tell me, change track. Don't go there. But for that luck. But at the end of the day, he said he did commit. After that, I think I don't like this criminal work. Then I shifted to civil. Fortunately, I was fortunate there because my father was an advocate in Jaffna, and all the appeal briefs sent here, the senior counsel written Dr. H.W. Jayawardena, Mr. Tyagalingam. So I am also marked as junior. I used to get 50 rupees. It's my fee. We didn't worry about that. And we learned a lot from them because they will train you, they will get you to get authorities, get you to read it to them and ask you what do you think. Do you agree? If you disagree, they say no, that's how we were taught. And they dedicated themselves to such teaching, So you need to, that is how you must start your professional career, not in buying Mercedes-Benz cars and coming to health stop and showing off your black coat. No. You have to work hard. And you must be fortunate to get a good senior to work under.
Sir, you are now almost 50 years standing in the bar, and you are one of the leading counsels. You must be having secrets and tips of your success, because not every lawyer can come to this level. Would you like to share those tips and your personal attributes that you believe when you handle a case or
Yes.
client?
Well, first thing is, whatever the client tells you is confidential. You must always respect their confidence. Otherwise, I always tell them that a lawyer, doctor is privy to confidences of their client or patient, which is not to be divulged to anybody else. So you must instill confidence in your client, so that he will, especially when the criminal side, so that they will tell you the truth of it. Because the law presumes, at least criminal law, you are innocent until proven guilty. So very often people ask you, even if you know the fellow is a murderer, will you appear? But the law says no, he is no murderer till somebody proves him. So that is exude confidence that they can trust you. That is on the criminal side. On the civil side, of course, you have to listen to the story and you'll be able to study the facts beforehand. If they come for I usually, even from very early days, when I am retained, I will tell my senior, sir, give me the brief, let's study it. You must study the brief, because when you go for a consultation with your senior, you don't go, as they say, with an open mind. No. They will expect you to contribute. You can't contribute unless you study the brief. We are not given junior's brief those days. You have to borrow it from your senior, and overnight you will sit and study. So we don't worry about dinner, or we don't worry about family or children. We need to study the thing, so that because the senior will expect some input from you. Apart from that, if you do input, those days solicitors, what we call proctors, they always sit at conferences. And they know, I say, this fellow has studied his brief. So then you are bringing yourself to the attention of solicitors, who will eventually brief you. Now you call it registered attorneys at law, but the legal firm. They will see the young fellow, he is working hard. I think somebody got to feed you. A lawyer cannot come on its own unless other people feel confident. They can trust you with a particular. That depends on how assiduous you are in studying and showing that you are a chap who can be relied on. So you must be attentive. Always make sure you study your brief. You are going to a senior. You may be asked, sometimes you may not be asked, but then if you have studied, you can then study how the senior is approaching the case. When he quizzes the client, then you will know why he is asking that question that you hadn't thought of. Then you will know why he did it. Because it may be useful for cross-examination, may be useful to bring out your case better. Because you are like a marketing man selling a product to a judge.
Exactly.
You can't decide victory or whether you will win or lose. Is not. You are selling your product, your client's product, to the judge. So you got to market it in such a fashion that the judge understands. So that one lesson I learned from late Mrs. Advocate Q.C. Nadesan, late senator. He said always you must study your judge more than your brief initially, because you may be a brilliant man, but if you cannot convey to him what you want convey in the way that he will digest it, then you have lost your case. So study the man. Is he irritable? Is he friendly? Does he know the subject? Or does he think he knows everything? So you got to handle. It's a human problem. You got to handle him. Don't think you know the law and go before. It never works, because you are involved in human interaction. So basic thing is study. You have to study. You should not say I must go for a suttu and come back and study. You can't. So that is one thing. Other thing is you need to read all around. The lawyer must know everything. Namely, what is the current fashion, who is the president of so-and-so, what is the political context, what is happening in the country, what is in the art, what is history. All those things you must know, because somewhere down the line it will become useful to you in the matter of cross-examination. It's very important, because you must know, if you are cross-examining a witness, you must know where is this boy coming from. You see, what is his background. So if you are doing a foreigner, you see, very often in the commercial courts we have foreigners coming. Which country is he coming from? You see, some of these horror countries like British Virgin Islands, they have all these horror accounts and that and this. Then you should know those countries are intended for that kind of operation. So you have to read all around. Because sometimes if you want to make a point, you use the idiom of the language of the witness. See, an Indian, we called bad word. You can upset the fellow. The Britisher, we use English words in a way which has a different meaning to an English fellow. You can upset a witness if you want to, so that you can disturb him in cross-examining. These are little arts you learn because you understand the background of a man. You are cross-examining, and you must read whatever that comes to you. You must read. You have to read. Apart from studying your law and your law books, your perception must be very broad. Especially we are an island. See, we are island, so we are a maritime nation. You need to know about all the sea routes and what's happening around the world. So that when something comes in, it is always useful. So don't think you need to study only a law books. You must read around it, selected subjects.
That may be one different to other professions where the law you have to know everything.
Yes. You learn poetry, you learn scripture, you learn religion, you learn everything. Because if you want to cross-examine a man of a different religious faith or nationality or ethnicity, you must understand those people. If you want to win him over, you say the right thing. If you go and upset him, then you are not going to get anything out of his mouth to support you. You are cross-examining him. If you speak to him nicely, he will agree. You will eat out of your hand. So these are little tricks of the trade which you can start very early if somebody tells you these things.
Sir, you have appeared some of the leading cases in Sri Lanka, and surely you might be appearing in terms of monetary value, huge amount of cases, the money value. At the same time, you will appear in ordinary cases. Do you differentiate your attention to those two cases and clients, or what is your approach?
It's a common belief that cases with big, currently I am handling a case where a judgment has gone against my client of 4 billion rupees.
4 billion?
Billion. The legal point is not affected by the quantum of the money. Maybe 400 rupees. It should never make a difference to you. In a legally clinical manner, approaching a problem. Don't be scared because my God, 4 billion, I don't know what the hell to do. 4 billion or 400,000, the point, issue of law is the same. Have you proved your case? If you are claiming 4 billion damages, have you proved your damages? What is your evidence? Whether it's 400 rupees or it doesn't matter. So I should think, never be troubled by the monetary value of a case. Because as a lawyer, you look to the legal principles or the legal loopholes or sensitivities or the inadequacies in a particular case and fill in the loopholes. So your attention, I say personally, all my life I have done that. You must give an attention to a case whether he is a famous man or not a famous man, big money or small money, it doesn't matter. Of course, if it's big amount, you may charge a higher fee. For a man, you can't get that, which we do, or we do it free. But the legal problem may be tougher in a 400 rupee case than in a 4 billion case. Value should make no difference. It's the content of the case and what you have to do. So that I think you must give big or small the same attention because that is your obligation as a lawyer. If you are looking at the money to please the money bag, you may get your money, but then you may lose your case. It doesn't matter. Frankly, it doesn't matter what the monetary value is. Apart from deciding jurisdiction whether you go to the district court or the high court, the legal principles are not untouched by rupees and cents or dollars or whatever it is. So, never treat a poor man differently from a rich man.
So finally, there are almost 1,000 law students becoming lawyers every year. Now one say there is too many lawyers now coming to the profession, and so many people coming to practice to the bar, and some in fact most of people like us looking at big personalities like you and have dreamed to come to that level at some point. What is your advice to law students who intend to practice, who intend to come to the unofficial bar and to be a good counsel? What is your final line of advice for them?
Final line of advice is to recognize you are entering a profession. You are not entering a trade. You are not here to trade. You are a profession. A profession means much more than being educated. It has certain norms and practices, certain conduct that goes with it, certain conventions which must be followed. There are codes of conduct, of etiquette, how you address judges, how you address a case, how you do not say things which ought not to be said because they are false. There are so many nuances in becoming a professional as against a trader. Whether it's the medical profession or all these things, you have to first, then you must understand what this profession is all about. Unfortunately, the profession that we are practicing is not an indigenous profession. It's not what we now call, it's not homespun. It is a foreign experience, experiment that we are doing. Because, so where do these traditions come from? They come from England. Why do we wear wigs? You must understand. Why do we wear these white bands? Why do the judges wear these collars? Why are they doing it? It's not a circus. Why? Everything has a meaning. So what I am saying is, you must understand the legal history of any particular system to be able to appreciate the true sense of the profession. Because with that comes, these are foreign elements which have come. You see, we are trying to, especially children who have not been trained in these or adapted to learning in English language and things like that. You come into the profession basically as strangers to a legal tradition. What you have seen may not have been very helpful. So, if you want to blossom forth, you must think yourself in terms of international exposure. Because you may be a Sri Lankan lawyer, but the globe is getting smaller and smaller, globalization coming in. So, you are going to deal more with foreign people. I'll be dead and gone, but you guys are going to, for the next 20, 30, 40 years, you are going to deal more with foreign people than you will be locally. Because we are a small island, we can have tremendous potential in the future, politics apart. So that you need to understand cultures. You see, because first lesson we are taught when you do law in England is the legal history. What is equity? What is law? What are legal maxims? What are they? What do they mean? You must have. So you must understand that. So my advice to young lawyers is, forget about earning money the first day you step out of law college and get yourself enrolled and taken to the photograph and have a party with your family. That's natural. Learn around the profession. Understand the legal systems that you are studying, going to work in. And recognize that you are a professional. You are not a trader. You are not come to trade your services to get money from a fellow and play him out and go to the other fellow. You are not a trade, you must remember that. Then which means that you have to be focused on delivering a service. You are being paid for it. So you must be conscious of the fact that people depend on you. Or you give them the best. If you start with that approach, you will find that you will go very far.
Thank you very much, sir. In fact, you shared with us today a very valuable set of experience and advice. I am sure this is very helpful for the law students as well as to the young lawyers. I thank you very much.
Thank you. I hope so. Thank you very much. Thank you.